My testimony will be a little bit more, a little personal and a little historical in nature, and I hope you have a little bit of patience with me. My name is Jorge Renaud, and I'm a policy analyst with the Texas Criminal Justice Coalition. In 1977, I was in prison on a unit for youthful offenders in TCJC, in what was then the Texas Department of Corrections, not TCJC. I was assigned to a 48-square-foot cell, and there were three of us. There was one person on the floor on a mattress and one on each bunk, and this was pretty well common all the way down the runs. There were mattresses up and down the tiers. In December of that year, I had my ear almost torn off. Then I had it stapled together by an inmate. That's the way it was. Inmates were the ones that provided medical care. TCJC at the time was pretty well in the throes of upheaval. It was as a result of a barrage of suits that were consolidated under one plaintiff, David Ruiz, and it was Ruiz versus Estelle. But you would have never known that if you would have looked at the directors at the time, first George W. Beto and then W.J. Estelle. They were in a crisis. And unfortunately in Texas, and well, it's not just Texas, but the way that policymakers usually respond to problems in their carceral institutions is only when they are in crisis. We don't go in any other time. Almost every right and every privilege that is designed to make our prisons more conducive to rehabilitation and to dignity and to provide dignity in our offenders are the result of offender-initiated litigation. They are not the result of public policy. They are not the result of administrators extending anything to an offender. From Cruz versus Beto, Lamar versus Cofield, Guajardo versus Estelle, Reese versus Estelle, the right to correspond privately with your attorney and to correspond with public officials and to correspond with the media was as a result of litigation. The right to have contact visits, to hug your child, was a result of litigation initiated by inmates. The right to have medical care that was not provided to you by inmates was a result of litigation by offenders. The right to have programmatic activities and regular recreation was a result of lawsuits brought about by offenders. Other than basic education, it was in fact initiated by well-meaning directors such as O.B. Ellis and Beto. Almost everything that is in place to provide an offender true rehabilitation was a result of a lawsuit that was fought at every step of the way by the administration. Unfortunately, that's true. And one of the things that they fought a lot was something called the building tender system. They referred to earlier about the lack of staff. Well, as a result of lack of staff in the 60s and 70s, Texas had what's known as a building tender system. Now, I'm sure you've heard of that. They were inmate guards. And what happened was the administrators and the wardens picked the ugliest, roughest, bloodiest, neatest convicts, and they allowed them to be armed. And they had chains, and they had truncheons, they had billy clubs, and they are the ones who took care of the units. And yet, in 1973, this body, the Texas legislature, passed a bill that was called the Building Tender Bill, that specifically prohibited TCJC from putting one offender over another. And yet, the building tender system was in place, and it was denied in every hearing. It was denied in every courtroom. It was denied in every lawsuit by every administrator until 1982, when then Attorney General Mark White, who was defending the state, finally threw up his arms and said, I can no longer believe the administration. I can no longer believe the wardens. It is true, and negotiated a settlement with Judge William Wayne Justice. That lawsuit and all the lawsuits before that cost Texas millions of dollars. Some of what you're going to hear today about prisons is that they're going to be woefully short of staff, and a lot of it's going to be about the lack of proper medical care. TCJC is nowhere near the crisis that it was back then. No. But it is, in fact, in a crisis. And I think that it's not fair to either the offenders, their families, the taxpayers of the state to wait until it becomes a full-blown crisis before we respond. I want to leave you with something, with one line that came out of another courtroom when TDC at the time, when someone proposed independent oversight. And this is the 10th District Court in Houston. They said that while it is probably fair to assume that most prison administrators would initially react adversely to the creation of an ombudsman, since the very nature of the constant scrutiny by an individual or agency representative of the state citizenry, it can serve a highly beneficial function from the prison administration's point of view. The providing of an early warning of developing problems within the institution and the clarification of the truth as to what actual conditions and procedures exist in the prison units. I urge you not to let this become a crisis, and I thank you for allowing me to testify.
All right, thank you for your testimony. Appreciate you being here. Members, any questions here this afternoon for Mr. Renaud?
Thank you.
Very good. Thank you, Jorge. Appreciate being here.